Hi, this is Attorney Heather Poole. Today we're talking about conditional green cards and whether it's time for you to file a joint petition to remove the condition or whether it's appropriate to file a waiver. There's a lot of information on our website already on these options, but we're going to talk more specifically about the common scenarios. A joint petition is usually filed when someone has a 2-year green card, they're still living with their spouse, and they trust their spouse will continue to not only sign the papers, but show up for the interview and not sabotage their immigration status. Sometimes an interview can be a year after you actually file the case. So if there's any doubt that your spouse will not be cooperative, perhaps you should look into an option called a waiver. One of the common problems we have is people who are trying to apply for divorce and they have a conditional green card. How long divorce takes will also determine what waivers are available to you. Obviously, if you're getting a divorce, your spouse is probably not cooperative, so a joint petition is usually not going to happen. Even if a joint petition started that way, if you get divorced, they're not going to be able to approve a joint petition. You're going to have to file a waiver anyways. So the first kind of waiver, the good faith marriage waiver, does require that you have a formal final divorce decree. This can be a problem if you live in states such as California that requires at least a 6-month waiting period. Now, a lot of immigrants take for granted that only that waiting period is what they need to determine in how long a case will take. Sometimes even after the waiting period has expired, the case will sit on a judge's desk for many months. Or if the case is contested, your spouse can draw it out for a long time. So you wouldn't be able to apply for a good faith marriage waiver unless you could get that divorce decree for certain. The other kinds of waivers may be more appropriate for you. The second kind of waiver we're talking about today is the extreme cruelty waiver. This is for someone who has experienced extreme psychological, financial, and/or physical abuse from their U.S. citizen spouse, and for that reason, that spouse is no longer cooperative and they have to file a waiver. The abuse can be any combination of those 3 types, or it can be one of those types, though it is going to be harder to prove financial abuse alone without any sign of psychological abuse. Now, this type of waiver does not require a final divorce decree, so that is the advantage. The other advantage to this type of waiver is that you can still apply for citizenship within 3 years if the waiver is approved based on cruelty. Usually the rule is that if you separate from your U.S. citizen spouse and you eventually get a waiver approved, you cannot file for 5 years to become a citizen. So this is one big benefit. However, these cases can be difficult to prove and can be emotionally exhausting. So you always want to talk to an immigration lawyer about your options and whether you have the proof available, which is any credible evidence, to really support your case. The last kind of waiver available to you is the extreme hardship waiver. This is one of the more labor-intensive waivers because it requires that during the past period where you have received conditional residence, that extreme hardship has arisen, that if you had to leave the United States, you would suffer extreme hardship. Now, the difficulty is if you just got your green card, immigration is only going to consider hardship that came about after you got your green card. So if you got it last month, it's going to be literally impossible in most circumstances to show that hardship all of a sudden came up in a month. And hardship is not defined as losing a home or losing a job or access to loved ones. It's something that has to be extreme, something unique to your situation that most others facing the same kind of consequences would not be facing. So again, talk to an immigration lawyer to determine what is the best option for you, whether you want to go forward with a joint petition or whether a waiver may suit you better. If you want my help with your case, feel free to give us a call.